Good afternoon and welcome to the New Civil Liberties Alliance. Today's Lunch and Law program is entitled, How Could SCOTUS Get the CFPB Case So Wrong? And here to discuss that question are three seasoned litigators who can shed light on this question from some different perspectives. To my immediate left is Louis Capozzi, a former law clerk to Justice Neil Gorsuch, appellate litigator at Jones Day, and a lecturer at Penn's Carey School of Law. To his left is Adam White, executive director of the C. Boyden Gray Center for the Study of the Administrative State. And to my far left, which I don't get to say very often, Rich Samp, my colleague both at the Washington Legal Foundation, more recently retired senior litigation counsel here from NCLA, and counsel to Crystal Maroney in the CFPB case that NCLA had at the U.S. Court of Appeals for the Second Circuit. So we'll have three different perspectives on the decision. And let me just start with maybe the premise of the question: how could SCOTUS get the CFPB case so wrong? Did it get the case wrong? Adam?
Well, I definitely think the court got the case wrong. Just by way of background, before I was at the Gray Center, I worked with C. Boyden Gray at his law firm, and we helped to file some of the original lawsuits against the CFPB's funding structure around 2012. And so the case that Boyden was making then, I thought was right, and so I very much agree with Justice Alito's dissent. Having said that, I will say I don't think Justice Thomas's opinion for the court is we'll say laughably unreasonable. I think it was wrong in the end. I think Justice Alito got the better of the argument. But to Justice Thomas's credit, I thought he had a pretty straightforward textual analysis that I think took too limited a view of the original meaning of the text. I'm not going to fault it for being, horribly bad. I do think, though, that Justice Alito definitely got the better of the argument.
Maybe taking half a step back, Rich, what exactly did Justice Thomas hold for the court in the case about the CFPB's funding mechanism?
The issue is the appropriations clause of the Constitution, and what it really came down to was what is the money that is being spent by CFPB? Did they get it as a result of an appropriation? And he tried to find dictionary definitions of that word from the period, and he said, well, yeah, I think that these were appropriations, and that's the end of the case. I think that Alito did a very good job in his dissent in pointing out that really the term appropriations had developed a special meaning by that time. There had been such a lengthy history of Parliament, in particular, in the 17th and 18th centuries, trying to make absolutely sure that it had the power of the purse, that the whole point of the Appropriations Clause was to put real teeth into the limits on the power of the executive branch to spend money that had not been authorized by Congress. And I think he made a very persuasive case that the structure that was adopted by Congress in setting up the CFPB probably did not comply with what the original founders had intended by the term appropriation.
Lou, I'll let you get in on this question. When the court struck down the director of the way that the director was appointed for the CFPB, one of the things that struck me in that decision, it talked about how it was often a signal that something might be unconstitutional if it was sort of new and kind of a novel way of doing things. Well, this certainly seems to be a novel way of funding. The majority didn't really look at it that way. It seemed to try to fit this within the history of other uses of the Appropriations Clause. But what's your take on what the court decided here?
Yeah, well, it's great to be here. Let me just start with a quick disclaimer. I do work at Jones Day, which represented the petitioner or the respondent in this case, but I actually had nothing to do with the litigation of this case. I was still barred under Supreme Court rules from being involved. So I was not privy to the strategic discussions, and my comments and my views are just my own.
Okay.
That being said, to answer your question, I think it depends on the level of abstraction that you look at the historical analogs. And I think this case, in many respects, is a useful practice lesson. And this is something worth thinking about going forward for people that litigate against the administrative state. For a long time, the sort of left-right divide, if you want to oversimplify, was do we do originalism in history or do we not? You think about issues like abortion and substantive due process. I think that kind of made sense. We've now moved on to, I think, a different kind of strategic battle where both sides do history.
We're all legal historians now?
Yeah, we're all legal historians now. And look, I was rereading the oral argument transcript this morning. Solicitor General Prelogger's first argument was about the Army Appropriations Clause, which provides, at the very least, more substance, more teeth to limit Congress's ability to delegate away the appropriations power. And Justice Barrett, her first question was...
Can I just interject there for those who may not have followed the oral argument or read the decision? What Lou is referring to is the Constitution specifies a 2-year limit in terms of Congress being able to fund the Army, specifically can't fund the Army for more than 2 years at a time. And the court said in Justice Thomas's decision, well, the fact that it specified that 2-year limit means that it was aware of the fact that you could have such time limits, didn't put time limits on anything else, therefore, Katie bar the door. I guess it didn't say that, but that's the implication.
Yeah, and I think it's telling that was right out of the gate Liz Prelogger's first real argument. She also spent a lot of time talking about the Customs Service enacted in 1789. And then Justice Barrett's first question and argument, she asked about an amicus brief written by constitutional historians, which are really, they're just a bunch of leftist law professors, but still,
self-identified constitutional historians.
Yeah, I mean, I look, some of them are very nice people, but the strategy at this point from sort of the left in these cases is just going to be kick up some dust, try to complicate the history. I mean, I think we saw this done as well in Moore versus Harper and the Elections Clause of the Constitution. And so really, what do you do then when both sides have some historical points and these sort of cases are going to be decided really on the details? I think one potential answer going forward to that dilemma is we need more robust historical legal scholarship, something we really didn't have with the Appropriations Clause in this case. I know Adam has things to say about that.
I mean, people are still referring to Kate Stith's article from, 1990 or thereabouts?
Yeah, the President's Power of the Purse, was it?
Yeah, something like that.
Yeah, this is one thing I was struck by, again, since I was working with Boyden on these issues back in 2012 when we and others filed the original briefs in another case. I was struck when Judge Edith Jones in the Fifth Circuit put out her concurring opinion in another case that in the Fifth Circuit, ahead of the Fifth Circuit panel in this case. Most of the material in that opinion, when I went and sort of cross-referenced it, was things that Boyden and his colleagues had put in briefs in this other case 10 years earlier. And at first I thought, wow, that's kind of great. And then I thought, no, that's actually a very bad sign. There hasn't been any real scholarly development of this issue since then. And so I think Lou's exactly right. One thing at the Gray Center that we'll be doing in the year ahead, we're going to co-host a law review symposium. We haven't announced it yet. I guess I'm announcing it here. A law review symposium.
To do so.
Thanks. Yeah, a law review symposium of articles on the future of the power of the purse and the aftermath of the CFPB case and the student loan cases and others, trying to both deepen the historical scholarship on this subject. There's a handful of articles by Gillian Mesker, Matthew Lawrence, Christine Chabot, and Eloise Pasikoff. I think they'd all say they're on the center left. We're going to help encourage those debates with more scholarship and also broaden it beyond just, say, the CFPB case and the loan case, but thinking more broadly about Congress's power of the purse in foreign affairs and other places. Really try to introduce this more broadly into constitutional administrative scholarship. Admittedly, a little bit too late for this case, though.
So Rich, the title of our talk today, how could SCOTUS get the CFPB case so wrong? I think it's fair to say that once the oral argument occurred that folks were a little bit queasy about how the case might come out, but I'm not so sure that was the view ahead of oral argument. What do you think changed, or what do you think it was about this case that caused the court to come out the way that it did? I mean, is this, a cynic would sometimes likes to say, well, the court had a predetermined outcome and reason back to it, but I'm not so sure that the folks in the majority of this decision necessarily liked the result that they came up with. I think this was an honest attempt to read the historical tea leaves.
I do think that perhaps in some ways the CLO law decision, which was the prior case about the CFPB, was kind of the high watermark of people who were saying we really have to control what the administrative branch tries to do independently without being controlled by either the president or, in that case, or by Congress in this case. And I think that those same instincts would have led perhaps a majority of the court to rule against the CFPB. But the problem, I think, from their perspective was there really was not, in their mind, an easy way to cabin the case. That yes, this was a very unique funding structure that really does take away the power of Congress to control the CFPB because, as many people pointed out, Congress can try to change the law to cut back on what was granted by the Congress back in 2010, but the president can veto that, so it really doesn't have the power of the purse. But the problem was, if you strike it down here, I think a lot of people in Washington think that the Federal Reserve System has worked reasonably well for the last century, and if we adopt a decision that's going to throw the Federal Reserve into its constitutionality into doubt, maybe that's not something we ought to be doing. And I do think that that was perhaps a weakness in our side of the case, was that we were not able to articulate a clear line as to why this case goes too far in terms of abrogating Congress's power, but we're not going to throw out the entire Federal Reserve System.
Can I just add on to that?
Yeah, absolutely.
An observation. I mean, I think that's exactly right. Justice Barrett's second question during the oral argument was really pressing my colleague Noel Francisco for a more specific red line test. And some of the hypotheticals that were offered then later in the argument really got at that. The justices were grasping for kind of clear lines, bright line rules, because I think they were worried about the Federal Reserve. I mean, you can call it the Federal Reserve canon. If a rule would threaten the Federal Reserve, they're just not going to go there. And then in the opinion itself...
Why wouldn't it be enough to say, with regard to the Federal Reserve, look, it's fine if you have an agency that's self-funding, but you can't have another agency pulling from the funding of the self-funding agency, in the same sense that it's fine to have one layer of protection from ALJs, but you can't have two layers. I mean, this seems like a double removal sort of problem in the same sense that the court wasn't happy with in the ALJ context, but seems fine with in this appropriations context.
Yeah, I actually think the court held open the possibility of a sort of double appropriations removal type holding. The majority opinion by Justice Thomas emphasizes that it was Congress, not the Federal Reserve, that set the cap. And so they held out the possibility at the very least that if the agency or, if the agency intermediary is the one setting the cap, there would be some kind of claim. But they could have drawn that line, and they chose not to. I'm not sure how clearly that line was put forward in the briefs or in the arguments. It didn't come out when I read them.
One of the things that Justice Thomas says at the very end of his decision is, although there may be other constitutional checks on Congress's authority to create and fund an administrative agency, specifying the source and purpose is all the control the appropriations clause requires. Any idea, Adam, what he's getting at there? That seems like a veiled reference to something.
I don't know what he's getting at. Here's a guess of what could fit that bill. And again, being a Boyden Gray protege, you won't be surprised to hear it's the non-delegation doctrine. I always thought that this issue is best understood as a kind of non-delegation to Congress. It wasn't so much about the meaning of the word appropriations, although again, I think the majority got it wrong here. I just have to say as a footnote, for its entire existence, the CFPB has said over and over again and continues to say, we don't get appropriated funds.
Right.
And so I took them at their word all this time. The court didn't.
But the statute says that these funds shall not be counted as appropriations or worse to that effect.
And the CFPB continues to say we don't get appropriated funds. The only person who actually thinks that the CFPB does get appropriated funds is the Supreme Court. But in terms of
Obamacare is a tax.
Well, I thought you might have mentioned that. Yeah. in terms of the separation of powers principles, other constitutional principles, I think that this is an issue of delegating away Congress's power of the purse in the same way that Congress can sometimes delegate away its lawmaking power. The CFPB's funding is a perpetual, open-ended grant of money. I know there's a nominal limit in the statute. The agency has never come close to actually meeting that limit here in the real world. In fact, they have fallen so short of that nominal cap from year to year, they amass a stockpile of a rainy day fund to use in future cases, so much so that OMB Director Mick Mulvaney, I think, once drew just $1 from the Fed because they didn't need any more money. The agency had already banked so much. And so I wonder if there's a non-delegation claim there, that an open-ended, an open-ended in terms of time and an open-ended in terms of amount a grant of spending authority to the CFPB. Perhaps that's a non-delegation argument. I sort of framed it that way in writings up to the case. One law professor in an article about this actually at the outset said there are some activists who are trying to reframe the CFPB case as a non-delegation case, and she cited in a footnote my little blog post. So at least one person was listening. But given Justice Thomas's sense of non-delegation more generally, I do kind of wonder if that's what he was getting at. I hope.
Any other theories as to what he might have been getting at, or what other constitutional limits there might be? I mean, the dissent says, I think I have this right, that this is has turned the appropriations clause into a vestige of the Constitution. If that's true, then what's left of the power of the purse?
I thought that Justice Alito did a very good job of showing that the framers' intent to control, to make sure that Congress had the power of the purse, was articulated through the appropriations clause. So that if the appropriations clause doesn't do it, I can't think that there's possibly any other provision in the Constitution that really directly addresses it nearly as well as the appropriations clause does. So I think it's just Justice Thomas's way of saying that, well, this is a narrow provision, so it doesn't apply, and I'm not going to concern myself with what might otherwise apply.
I mean, it is remarkable how much the court's majority opinion just collapsed the constitutional phrase. I don't have the exact wording in front of me, but it's in it. No money shall be drawn from Treasury except by consequence of appropriations by law. I think that's it. Yeah. Mont Bueller's getting it out. He always has his Constitution. I should too. But the majority opinion, in effect, collapses this down into just no money shall be drawn except by law. It sort of makes appropriation synonymous with law. And that, I think, at the end is where the court really gives short shrift to the constitutional text. Did I get it close?
Yeah.
Okay. No money shall be drawn from Treasury, but in consequence of appropriations made by law. And so they collapse it down to no money should be drawn from Treasury except by law. I think Justice Alito's dissenting opinion really does give meaning to the term appropriation and not just read it out.
Go ahead, Lou.
Yeah, so on the issue of delegation, you're right, of course, this case was not formally litigated as a delegation case, but if you read the respondent brief, delegation is very much like the primary theme that they emphasized, and this certainly came up during oral argument. I mean, the Chief Justice's first question was about this sort of the same issues we have with delegation is once the power is given away, it's really hard to get it back. The president can effectively veto any attempt to take the power back, and then Congress's only tool left in the bag is to threaten to shut down effectively the entire government.
Yeah.
And even that doesn't work with the CFPB because they have $340 million in reserve to keep going.
Yeah, I mean, so basically you have to shut down the entire government for a very long period of time.
Yeah.
I mean, it's the sort of nuclear option that anybody who understands DC knows would never happen. And so we now have with the appropriations power the same issue we have with the legislative power in general, which is so much of it has been given away. There's no realistic way to get it back. And this should make people who want a robust non-delegation doctrine a little bit concerned. The court heard this logical argument and it rejected it. Justice Kavanaugh during the argument said, well, Congress could just pass a law and claw back the appropriation power. And,
very naive, I thought.
Noel Francisco pushed back on that and said, as a practical matter, that's just not going to happen. And then Justice Kavanaugh said, well, you could just decline to fund the government then. And so that sort of logical exchange is exactly the sort of thing
that comes from someone who's served in the executive branch but not the legislative branch, I think.
Justice Kavanaugh, we hear at a CFPB case on the D.C. Circuit, and it was focused, this is in the run-up to CELA, they focused on the executive power issue, and in a footnote he made reference to the power of the purse argument, and he said something like, at worst, this is just extra icing on an already unconstitutional cake. It was a nice line, but I always assumed that Justice Kavanaugh was not going to be favorable towards this argument.
So is it a vestige then? Rich, do you want to weigh in on that?
I think so. I don't see any future under this decision for cases brought under the appropriations clause, and that's why I think Adam is right to start looking elsewhere for limits.
Yeah. Let me jump back to the majority. So one of the criticisms that's made of reliance on legislative history is, and I can't remember if this was Justice Scalia who said it's like being at a cocktail party and looking over the crowd and picking out your friends, and that's what happens with legislative history. Are we at the risk of that happening with constitutional history as well? I mean, both sides here are quoting Maitland and some of the same, very same sources, but just citing different parts of them. I think that the Second Amendment aficionados were fans of the court's use of history in a recent Second Amendment case. Here, I think that folks who thought the Appropriations Clause served a very important separation of powers function may not be as happy with how history is being employed. Is history? Are we expecting history to do too much work here for the court? Maybe is how I'll phrase that question. Or is the court expecting history to do too much work for it?
Well, this has always been a tension within originalism and textualism, being very wary of use of Congress's legislative history in interpreting statutes versus reading the writings of the founders with an eye to the meaning of the original Constitution. So that tension has always been there. I've always liked that line about the looking across the room, picking out your friends. But I think the lesson is not that there aren't friends in the room, right? The lesson is that the one doing the picking has a lot of discretion. And I think there will always be room for both lessons from the constitutional foundings era and also lessons from legislative debates that can be in good faith incorporated into textual analysis. But it really requires a lot of honesty and self-restraint on the part of the judge to do it.
Yeah, what I would add to that is, history is complicated. With a lot of these clauses, history is complicated. We've seen this in the non-delegation debate. The attempt of Professors Mortensen and Bagley to really dirty up that history. I
was going to say hijack, but yeah.
Yeah, I don't think they really pulled it off. But I think that again, if you are resisting, if you're sort of on the left in a case like this, just kicking up dust and making the things seem complicated, that could be enough. And another question we have to ask is which history is relevant. The concurring opinion in this case, basically says
from Justice
Kagan, but joined by Justices Kavanaugh and Barrett, basically suggests that history, even in the 20th century, can be relevant to deciding what these constitutional provisions mean. And it's a little bit, I guess, bizarre for me. I mean, Justice Barrett wrote an opinion last term in a case called Samia, critiquing Justice Thomas even for using historical evidence from the late 1800s, but now evidence from the 1900s is relevant, or at the very least, it's relevant if there is, as Justice Kagan claimed, an unbroken tradition. If there's not that tradition, if you can't kind of draw the line, maybe that evidence is not relevant. But that's a big open question for me.
Adam, you mentioned that Mick Mulvaney had drawn $1 at one point when he was the head of the CFPB. Yeah. I guess that causes me to think of two different questions, but one is, so now that CELA law has been determined and the president is presumably entirely in charge of the CFPB, aside, I think that makes the separation of powers problem worse. But does that mean that the president could direct the head of the CFPB not to take any money? And so in a way that the president can't do for any other agency, can actually refuse to implement the law?
Yeah, I think that's right. The discretion cuts both ways. And so I think in the future, different presidents will approach this agency in very different ways.
So it could be the case that Congress has bought the ability to prevent Congress from interfering with appropriations in the future, but it hasn't prevented a future president from completely shutting down an entire agency just by refusing to spend any money.
Yeah, and if you're reading of Dodd-Frank, is that it basically vests that immense discretion of the CFPB director and the president without any constitutional constraints, then on its face, Dodd-Frank becomes a statute enabling presidents to turn or turn off an agency like a light switch in a way that I don't think any other agency has ever been structured.
Yeah, I think that's right and somewhat concerning. The other question is, and this was suggested by Peter Wallison, your AEI colleague, that what about the fact that sometimes the Fed might not have earnings, and so if the statute is calling for CFPB to take revenue or to take funding not to exceed 12% of total operating expenses, but that money has to come out of the earnings of the Fed, and there are no earnings for the Fed, and apparently there haven't been earnings for the last couple of quarters at the Fed. Would that be another way in which the money might dry up for the CFPB?
Yeah, this is a huge problem with this statute. The fact that the CFPB's funding is not keyed to the Fed's profits, it's surplus that goes to Treasury. It's keyed to the Fed's operating expenses, 13% of operating expenses in maybe 2015, adjusted for inflation. So the CFPB always has a good year, even when the Fed doesn't. And as I wrote in a piece that I think came out the morning of the oral argument in the Wall Street Journal, the real threat to the Fed here was not ruling against the CFPB's funding structure, because I do think it can be distinguished from the Fed. The real threat to the Fed here is in the long term. And it is a signal to Congress that you can and maybe even should structure independent agencies to be funded completely out of the Federal Reserve, turning the Fed into a kind of slush fund for the administrative state. That's the real threat to the Fed, not the sort of taking the CFPB decision in the other direction and over-reading it in a way that would shut down the Fed. This was true from the very beginning of the Dodd-Frank litigation in 2012. People always tried to say, oh, if you rule against the CFPB, you're killing the Fed. They said this about the executive power arguments too. It was like that old National Lampoon cover right by this magazine, or The Dog Dies. It was over and over again, you cannot rule against the CFPB unless the Fed dies. I thought it was ridiculous.
I want to add, there has been
please.
a number of articles written since the case came down, people suggesting that because maybe the Fed is technically insolvent, that somehow that the Supreme Court decision requires that there be no more funding of the CFPB. And I can't say I've followed that argument all that carefully, but from the little I've read of it, that makes no sense. I mean, the decision says that it is an appropriation, and that's good enough.
Yeah, I agree.
Yeah, I shared skepticism when I originally read the article, but I haven't followed up the way that it sounds like you have. I wonder, I have a sort of a different separation of powers question. Justice Jackson, in her concurrence, says essentially, hey, and the judiciary shouldn't be messing with the CFPB either, right? But isn't that exactly what the court has set up here? Because if Congress has been taken out of the equation and Congress is no longer able to serve the checking function, ordinarily you have two branches checking a third branch, but Congress and the power of the purse is now out of the picture. So the only real remaining check on the CFPB, other than, I suppose, the president himself, is the judiciary. So it seems to me that this decision effectively increases the power of the judicial branch, or at least increases the responsibility of the judicial branch for being the only one to keep an agency in check. I don't know if that was the intent of the court. I'm not suggesting it was, but isn't that the effect? Lou, what do you think?
I mean, yes and no. I guess the reason I'm thinking maybe no is I'm struggling to see how the court will check the CFPB. I mean, I think the answer is maybe just it's the president and only the president. Now that sort of the removal and the appointments issues are off the table and the appropriations issues off the table, what is going to check the CFPB, which was given very express, very clear statutory authorization to basically do whatever it wants in enforcing Dodd-Frank and the new financial standards contained within. And so, I think one thing that we have to do some thinking about is, well, what are the ways that the courts could check the CFPB going forward? It's not immediately apparent to me what those are.
Well, and Congress gave the CFPB 18 statutes to enforce. Plus, it created a new sort of wide-reaching obligation for the CFPB to go after other kinds of kind of financial fraud. And so I do think it's pretty broad, but I still think that there would be room for a court, for example, and I think this issue's already been decided, but there was some discussion that CFPB was trying to reach out and regulate auto lenders.
Yeah.
And it was very clear when this law was passed that the one thing CFPB was not given control over was auto lenders.
Yeah.
A very powerful lobby for one reason, but also, it's not clear that the pre-existing 18 statutes were, any of them covered auto lenders, and so this wasn't supposed to either. The CFPB nonetheless went out and tried to regulate auto lenders.
Yeah.
And so there would be a room for a court to say, no, you can't do that.
Absolutely, and I do think that because the funding is really off the table as a check on the agency, I think that the agency will continue to invite judicial review. Here's what I mean by this. Charlie Munger said, "You show me the incentives, I'll show you the outcomes." Here we have an agency that will continue to not have any accountability to Congress. And we've seen from the start the way that the CFPB, more than almost any other agency, has thumbed its nose at congressional oversight. In one hearing involving the CFPB's new building, the original CFPB director said to a member of Congress, he told her, she was asking all kinds of questions about who authorized
very lavish new building.
Yeah, he was being pressed for why you're spending so much on this agency, and he said to her, well, what business is it of yours? And she said, well, I'm a member of Congress, and he just moved past. The CFPB over and over again, I think, has exemplified the problems that you get when you don't have meaningful congressional oversight. And the CFPB, I think, is going to continue to exemplify those problems. If anything, it's going to have extra wind in its sails. And furthermore, administration-wide, I think that you'll see a natural incentive for administrations to do more and more through the CFPB. Get the CFPB more involved in cross-agency work because it doesn't have the same accountability to Congress. And so I think future presidents are going to have to be very careful to resist that incentive, because I think they're going to invite CFPB overreach that's going to give rise to more and more traditional administrative law fights around the agency.
I think that's well put. One of the things that Justice Alito focused on in the dissent that I didn't see the majority really talk about is the Statements and Accounts Clause. Mm-hmm. Is there any, and I don't remember the Jones Day briefs well enough. I don't know if you read them or not, Lou, back at the time. But was there an objection made to the CFPB under the Statements and Accounts Clause? Is that a potential reason why the CFPB might, the fact that it doesn't have to report to Congress, as Adam's talking about?
We're all looking at each other, hoping somebody else will answer this question.
Well, yeah,
right?
I mean,
if the Appropriations Clause doesn't do it, it would seem to be a little bit odd to say that the Statements and Accounts Clause, that robust one that has had almost no litigation around it, would jump in to do the trick. But
I believe this was
grasping for straws here.
Yeah. I believe this was mentioned in the respondent brief, but as sort of a minor supporting point.
Yeah.
Okay.
Yeah.
Well, Adam mentioned, Rich, that the agency has been unchecked, and more so than lots of other agencies. And that's something that we experienced here with our client, Crystal Maroney. Maybe I'll just invite you to explain sort of what's happened with that case now as a result of the CFPB decision here, but also to expound on the ways in which the CFPB was really off the leash there.
Well, Crystal Maroney ran a very small law firm whose clients were lenders who had debtors who were not repaying their loans, and she therefore was subject to the CFPB because the CFPB administers various of the laws that control debt repayment. The problem was that the CFPB had absolutely no limitations on its budget, and so they decided, Crystal has lots and lots of records about the practices of lenders. We don't really have any evidence that she did anything wrong, but maybe if we just get everything from her, we'll be able to put together a case. And if you've got an unlimited budget, why not spend all the money possible? Well, the result of all of that,
including attorney-client privilege records.
Sure. The result of all of that was that she essentially had to spend so much time she had huge numbers of tape recordings that she had made of every time her office would call a deadbeat borrower. She had to keep those recordings well.
Right, for compliance reasons.
Right.
So if they had said there was something wrong with this particular thing that you did, she had the recording, she could say, no, I didn't. Here it is. Like, here's the recording.
But she had to spend hundreds and hundreds of hours going through all those recordings. It meant that it really closed down her business. Plus, of course, her clients were a little bit reluctant to continue to use her as a lawyer if they knew that every single one of their records was going to be reviewed by CFPB. So the result was she eventually had to close down her business. And that was, as far as the CFPB was concerned and all of its litigation against us, well, that's just the cost of doing business. And you may get thrown out of business, but hey, don't worry about it.
And Crystal wasn't in the debt collection business, but her law firm was debt collection adjacent, I guess you could say. And here with the CFPB case, this was payday lending, right? So these are disfavored industries by the CFPB. They don't like payday lending. They don't like debt collection. And so they're able to use their administrative power in ways that other agencies wouldn't be able to, that DOJ wouldn't be able to, for example, to just sink someone like Crystal Moroney, not because she did anything wrong, not because she lost a court case about some substantive violation of the law, but just by inundating her with so many requests for documents that she couldn't both satisfy those requests and stay in business.
And let me the follow-up on all of this was we had a cert petition that was pending while the big CFPB case was being litigated. It was denied a week before last. And only after that happened, then CFPB contacted us and said, oh, okay, well, we're going to drop our investigation of Crystal Moroney. In other words, they were just keeping it going in order to be able to keep the issue alive. But they really never, that was an admission, they never had any evidence of wrongdoing. And she's now finally, 7 years later, totally in the clear.
Let me do something uncomfortable for me, which is play devil's advocate on this issue. There's something in contract law called a Ulysses contract, right? And it's taken from the story of Ulysses tying himself to the mast. And the idea is that there might be certain rational circumstances. Ulysses wants to listen to the siren song, but wants to be able to navigate through and not get destroyed by Scylla or Charybdis, right? Yeah. Is this a kind of Ulysses contract that Congress was making that said, we know based on our experience that if we go through the normal appropriations process for this agency, that eventually, we're going to decide to clip the wings of the agency. We're not going to be able to fund it the way we want to, and therefore we're going to do this kind of Ulysses contract that's going to do this funding that kind of ties our hands and ensures that the agency is funded. Should Congress be allowed to do a Ulysses? Sort of extrapolating away from the CFPB. Yeah, what's wrong with Congress doing a Ulysses contract?
If Philip Hamburger were here, he would launch into a speech about the vesting clause. These responsibilities that Congress has are vested in them, not just for Congress's benefit, but for the people's benefit. The people, they vote for elected representatives. They're supposed to make decisions about, for example, how to regulate the payday lending industry. And that authority has been alienated, and we are increasingly getting to the point where why do we even bother to vote for representatives? They're not making the most important decisions in our government. And, so you might say, well, past representatives gave it away. Why can't they be held to that choice, just as you could in contract law? But again, that's why the powers and the authority is vested. It's not just for Congress's benefits. It's for the benefit of all people, all American people.
Well, in today's electorate didn't vote for the Congress of 2009, 2010. In fact, the American people voted out the Congress of 2009, 2010. One of the things that's always bothered me about the way the Supreme Court has handled both the Obamacare litigation and the CFPB litigation, with maybe the exception of Saylor Law, is you had the American people overwhelmingly speak in November of 2010 to turn out the Congress that passed Obamacare and that passed Dodd-Frank by overwhelming margins. So the Democratic response of the American people was to say, we don't like all of this legislation that Congress managed to get through. And yet the court has been there at every turn to defend the work of that Congress, which you may remember had 60 Democrats and then later 59 Democrats. I mean, it was a high watermark of Democrats in the Senate. They haven't reached that total since, and they hadn't reached that total for many, many years before that. And so they took full advantage of that to pass some very significant pieces of legislation. And the court keeps looking at that like it's defending democracy by defending these things. And I think Justice Jackson's the one that said, well, they can go back to Congress if they want to change it. The American people did try to change it. They elected a new Congress in November of 2010, and the court has just stymied every effort to either undo Obamacare or undo the CFPB.
Yeah, I mean, I do like the metaphor, except in the Ulysses contract, except of course in this case, Congress was not trying to bind itself, it was trying to bind future Congresses.
Right, that's a good point.
Ulysses can have himself tied to the mast, but if he started running around Athens tying everybody else named Ulysses to masts, that would not be allowed. That's not in the Ulysses contract.
Yeah, that's a fantastic point.
And we need to be clear, in 2010, the people who were the supporters of the CFPB had exactly what you're talking about in mind. This wasn't just a coincidence. They wanted it to be Ulysses' contract, and they feared that the Democrats might be voted out either in 2010 or soon afterwards. And that was why it was so important to put the power in the hands of the responsible Washington bureaucrats rather than the people who couldn't be trusted.
And that's my frustration, is that there seems to be no comprehension on the part of the Supreme Court of that dynamic at the legislative branch. And maybe we need more people with legislative experience on the Supreme Court.
You did mention Roberts. I mean, in the Peekaboo case, the Public Company Accounting Oversight Board case from 2010, he actually points to exactly this dynamic in the majority opinion, saying any individual president is going to have reasons to want to bind his successors, but it's the court's job to not necessarily go along with that.
Yeah, this is the paradox of the veto in our Constitution. I mean, I think the veto clause is turning out to be, one of the defining characteristics of a modern American government. The reason why the framers gave the president a veto is to make lawmaking harder. The king used to have a veto in the British system, and that had basically fallen into disuse. It hadn't been used in 100 years. And so there was a debate, should we give the president a veto or not, which was effectively the status quo in the British system. And they gave the president a veto to make lawmaking harder. And yet now, in modern American government, the veto functions almost exclusively to make preserving lawmaking easier. Because now, in our system, because of the consequences of delegation, the president and his agencies make law unless Congress, over a veto, can stop law from being made. And so the veto is really what's preventing the people and their representatives from taking their power back.
Yeah, it turns legislative delegation into a one-way ratchet.
Yeah.
So it's very difficult to get back any legislative power. One sort of unique quibble that I've heard about the court's decision is that this shows the problem with the cert question process. That because if you look at the opinion, and I think a couple of you mentioned this, that Justice Thomas's opinion for the court really narrows the question down very significantly, just to the meaning of, maybe not even the whole clause, but just sort of the word appropriations to some extent. And this case isn't unique in that regard. The way that the Supreme Court takes cases is that there are questions presented, they grant cert on those questions, and then they answer those questions. But the Constitution says cases or controversies. It doesn't say questions. It doesn't say questions for cert. So, and to me, when, in some sense, suppose it turns out, for example, that the majority's opinion about appropriations clause's meaning stays the same, is unmolested, but one of these other things that maybe Justice Thomas is alluding to, maybe it's the non-delegation clause, Article 1, Section 1, what have you, later is found to wipe out the CFPB. Well, that essentially turns this decision into an advisory opinion, in a sense, right? Which the Supreme Court's not supposed to give advisory opinions. But if you're not deciding the entire case, now I suppose the argument on the other side would be, well, party presentation principle, you can't reach out and decide questions that aren't there. But I just want, if anybody wants to jump in on, should the court be deciding cases rather than questions?
I mean, my personal view, I don't see an issue with this. I mean, the court takes interlocutory appeals all the time. Now, as a question,
Where only part of a case is
yeah,
implicated.
exactly. And then the case gets remanded, and ultimately, the Supreme Court decision might not end up making a difference in the ultimate scope of the case. That's been part of our practice for a long time. I'm not sure case or controversy gives us enough of a hook to say that an appellate court can't decide a discrete issue and then remand for further proceedings.
Yeah. I don't know. I'd have to think about the constitutional text, but I will say that at the end of my time on the Presidential Commission on the Supreme Court, known affectionately by some as the Court Packing Commission, I did say.
Thank you for your important work there.
Thanks. I did say at the end, something that came to me I hadn't really appreciated until my time on that commission was that the cert process, though I think it was well intentioned and it's reasonable in some ways. It does give the court enormous discretion in ways that I don't necessarily think are well suited to a court of law. I'm not saying like take it down, but I do think it deserves another look.
I'm not opposed to further looks. I do think that as a practical matter, it's a pretty good system that we have right now. I think that the whole purpose of the Supreme Court is to provide, the principal purpose is to provide guidance to the lower courts, who are the ones who actually decide cases. And if you don't allow the Supreme Court to focus on particular issues, they're not going to get decided.
They'll decide even fewer cases than they're deciding now.
If someone's interested in doing further research on this, William Howard Taft, when he lobbied Congress for the grant of certiorari discretionary jurisdiction, promised Congress that it would not really be a discretionary standard adopted by the Supreme Court. He said that he said, for example, that the Supreme Court could not use certiorari to avoid deciding important constitutional cases, which of course it does all the time. And in fact, multiple justices they openly defend the concept of discretion and just basically absolute discretion to refuse to take a case for any reason. And that might be an ahistorical approach to certiorari. Someone might look into that.
He said they were tying themselves to the mast.
Is the court saying go big or go home? I mean, maybe this just gets us back to the non-delegation discussion before, but
no. I mean, well, go ahead, Lou.
Yeah, no. I think the opposite lesson really comes from this case, which is I think this Supreme Court is very wary about using the Constitution to destabilize the administrative state. We saw that in SELA law, where, in my view, the court really destroyed traditional principles of remedies law, where we don't even give people...
Well, Collins even more, I would say.
Collins, we don't give litigants bringing removal claims a remedy just to avoid disruption to the administrative state. And this is certainly a dynamic I think we have to be thinking about when we approach non-delegation questions. The court's going to be very hesitant to do a big constitutional holding. You have this sort of principle from Holland v. Burkeen, and also from Justice Barrett's Fulton concurrence, which is we're basically just not going to do a big constitutional holding unless we know all the consequences that would flow going in. And so my own view is that's why you see the court turning to the major questions doctrine as a way to police non-delegation and not the non-delegation doctrine. I think this case kind of reinforces why they're doing that.
I certainly agree with that sentiment. I think that the upcoming decision that we're expecting in the next couple of weeks in the Jarkissi case will be a big test about the willingness of the court to take action that might well have significant impact on the administrative state. I think it would, if Jarkissi holds that basically there is no adjudicative power in the administrative agencies, that would be a major thing. I think there'll be some members of the court who will be reluctant to go that far, but I'm hoping that at least in that case, they will be willing to do so.
Yeah, or at least that there's a jury trial right, and leave it up to Congress to figure out if you're going to continue to have ALJs or administrative tribunals, how do you honor that jury trial right? And maybe you have the right to appeal to district court with a jury or something, rather than, not that I'm trying to make these processes even longer than they already are, but.
Yeah, and can I say a word maybe about small ball lessons from CFPB?
Sure.
So with respect to the CFPB, maybe the non-delegation issue is the last real challenge to the agency itself. But looking beyond the CFPB, there's, I think, a lesson about the power of the purse and administrative law more generally. As somebody who's taught administrative law a lot over the years, I've always been kind of interested in the fact that you spend a whole semester teaching about administrative agencies and process, you don't talk about agency funding. The power of the purse has always been a strange kind of blind spot in administrative law. And if the upshot of Justice Thomas's opinion for the court is that appropriation statutes are just, if laws are appropriation statutes and appropriation statutes are just a subset of ordinary law, then I think there's some interesting wind to the sails of some other issues I've been thinking about. To what extent should appropriations legislation be brought into interpretation of agencies' organic statutes? If Congress is legislating from year to year, sending funds to the EPA, sometimes they have very concrete riders on how to spend or not spend money. But maybe interpreting the provisions of the Clean Air Act ought to be done with an eye to what Congress has done most recently or in recent years in spending statutes. To the extent that there's a fight over an agency's policy choice, the kind of thing that gets channeled into arbitrary and capricious review, to what extent should the agency's available funds be brought to bear on the agency's justification for that policy? Should they have to answer why, given a limited amount of funds, they're pursuing this policy, and to what extent does it constrain other policies? One of the upshots of this case, I think, is it's opening the door, or it should open the door, to bringing the power of the purse into administrative law in much smaller bore ways. And it's something I'll be exploring for a long time. There's a couple other examples of this, by the way. You're seeing with respect to the Congressional Review Act. In October of 2023, the Government Accountability Office issued a report saying that an agency's policies on grants, how they're going to spend money, those things are themselves rules that are subject to CRA review. We're going to see agency spending decisions get brought much more into the CRA process. The Biden administration last year issued their new circular A4 on cost-benefit analysis. They set a 2% discount rate, or I think a 2 or 3% discount rate for weighing costs and benefits. Well, to the extent that federal spending is going to affect inflation, shouldn't agencies have to explain in ordinary administrative processes why the discount rate is still reasonable in an era of inflation? Over and over again, there's more and more hooks to bring Congress's spending into the administrative process and into judicial review. And I think, if anything, we're going to see a flourishing of that analysis in the years ahead. And I'd encourage litigators to think in those terms, too.
We'll throw it open for questions here. Well, actually, I see hands already, so why don't we just do that now? I'll come back for final thoughts after questions.
I went a bit long there. I'm sorry about that.
That's all right.
So I am convinced that CFPB is a bad idea, but I'm not convinced that it's unconstitutional. And none of you have mentioned that since the founding, the customs officers got paid out of customs, the postmaster got paid out of the postal things. As a structural matter, Congress is given power over the money of the United States to do with what it wants. Yeah. And as a structural matter, the Supreme Court interfering with their spending of money in any way strikes me as a separation of powers problem in and of itself. And the second problem here, it strikes me, is I think it's a straw man about having a filibuster-proof Senate, and that they wrote a law, and then the people threw them out, and the new legislatures came in, and they didn't write a law. And we sit around all day saying the written word as a law is what's important and not all this other stuff. So it strikes me that the majority opinion is very strong, and as a practical matter, Social Security is supposedly funded out of appropriations, but I think the funding structure of the CFPB will be overturned before Social Security's is.
Yeah. You know, Justice Scalia used to say he wished he had a stamp that said "stupid but constitutional." I guess that's the stamp. That's what you'd stamp on the CFPB. I mean, for what it's worth, I just disagree with the historical analogies here. To the extent that an agency like the Fed raises its own revenues out of its own operations, or the FCC gets licensing fees, or the FDIC gets insurance, it's one thing for an agency to raise its own funds through the services it provides or through its own open market operations. The Customs is the closest case, of course, because they're taking, in effect, tax revenue and they're keeping a cut. That's the closest case, but it's not even really what the CFPB is doing, which is just reaching into the Federal Reserve's pocket and taking out, $700 million. And Lou works for Jones Day, so I know he actually does have $700 million in that pocket right now. But the CFPB is really not even like, I would argue, the Customs Service, and I thought Justice Alito got the better of the argument by analogy.
I would just like to respond to the second point quickly. So the Congress comes in after the elections of 2010, and they did pass some laws. They did try to roll back some of what the Obama administration and the Democratic Congress has supported in 2008 and 2009. And
Yeah, I was there. I remember.
And
They did. At least the House.
Even if you could overcome the filibuster, and look, I think part of the conversation on legislative re-empowerment, we have to talk about the filibuster. But even if you could overcome the filibuster, President Obama could just veto the bill. And then you need 2/3 in each house. I mean, that is, ask yourself, when is the last time that the president's veto was overridden on a controversial piece of legislation? I would challenge anyone in this room to name a bill without Googling. The answer really is the Nixon administration at the height of Watergate. It's really only happened a couple times in American history where Congress has been able to overcome the veto. And so the veto is why once one Congress gives away its power, that disempowerment is effectively permanent.
Yeah.
Dodd-Frank prohibits congressional appropriations committees from considering the funds of the CFPB. Is it possible, and should Congress construe that as a rule of the House or the Senate that can then be unilaterally revoked or overturned without passing a new statute, and then consider the funding of the CFPB as a part of the normal appropriation process, reversing the ongoing continuing appropriation?
I have wondered, actually, the first part of the question, that could Congress simply disregard the earlier Congress's limits on two committees' oversight authority? That's a very, very good question, and I don't know what the answer is, but my instincts are in that direction, obviously.
Would that take a lawsuit by the Appropriations Committee against the CFPB, something like that?
Maybe.
Or they would just ignore it and wait for someone to challenge it?
Yeah, what would happen is an agency would issue subpoenas against the CFPB. The CFPB would defy the subpoenas, and then you'd have this constitutional issue teed up in basically a Mazars versus Trump kind of case. But I don't know what it means substantively for subsequent appropriations. I think it really is just limited to what extent could those two committees in Congress force people to appear before them and turn over documents.
Thank you for having this forum. A lot of great points expressed. Wanted to ask you all about a point that's been made by a professor of law named Chad Squitieri, I think at Catholic University. He's written for Florida Law Review Forum and Yale Journal of Regulation, that the proper question to be asked related to the, sort of what gives the Appropriations Clause its power, since it says appropriations made by law, is asking what law Congress can make, and that would have been the necessary and proper clause. As far as like comparing the post office, well, whether the post office is necessary and proper to carry out the power of delivering the mail, whether the CFPB is necessary and proper to go to the to carry out the regulation of interstate commerce, and that's the question that, if that would help with, as far as the lower courts, sort of continuing this line of inquiry as far as appropriations and whether Congress had the law. Just what are any of your thoughts on that? As far as what Justice Thomas said about other constitutional avenues of declaring null and void an administrative agency.
That's all I was going to say. Chad's very, very smart. He's always worth reading, and he certainly.
He was at our conference on April 10th talking about Philip Hamburger's, the 10th anniversary of Philip Hamburger's book.
Yeah, Chad's great and very smart, and I think he thinks that this is possibly one of the other structural claims that Justice Thomas's opinion for the court might have left the door open to. I'm still thinking about it.
I haven't read that, but thanks for mentioning it because I'll go track that down and see what Chad has
Did that
to say.
appear that appeared on the Yale Journal on Regulations notice and comment blog?
Earlier Florida, the Florida Law Review Forum.
Yeah.
It's on SSRN.
Got it.
Okay. I think I saw a question over here.
Hi. So one thing that I think of with administrative law is the idea of like an intelligible principle. And I'm wondering, like, what would an intelligible appropriation look like? It seems like the CFPB's appropriation was kind of like open-ended and indefinite. What do you think?
Well, that's definitely joined by the court here. Both the opinion for the court and the dissent talk about exactly that issue, how open-ended it is. I guess Justice Thomas would say, yeah, and that was true in year one as well, that Congress was doing very open-ended appropriations. If I remember correctly, the example he used was that Congress actually said, well, here's a big pot of money. We're going to divide it into 4 parts and use one part on this, one part on this. And so not a lot of specificity. I think when you mention the intelligible principle, that gets back to the non-delegation doctrine, because under current law, at least, in order to avoid the cut of Article 1, Section 1, as long as Congress has stipulated an intelligible principle, then it's done enough. I'm happy to throw it open to the panel whether you think that whether the Dodd-Frank Act has an intelligible principle for how CFPB is supposed to spend its funds.
I feel like I'm talking too much, but I'll talk again and just say I do think there's probably an intelligible principle there. I think to the extent that there's a non-delegation challenge to it, it's going to be part of a broader reform of the non-delegation doctrine, one that I hear about here sometimes. But also, when I was writing about non-delegation and the CFPB, I was tending to think more in terms of Justice Scalia's dissent in the Mistretta sentencing guideline case, where he said he favored a form of the non-delegation doctrine where you look structurally, has Congress completely outsourced a subject matter to be handled by another entity, not simply in like interpreting laws, but separate from everything else the agency was doing. And I tried to argue that's basically what the CFPB is doing here. It is the junior varsity Congress when it comes to funding the CFPB. It's not just a matter of like lawmaking discretion where you're interpreting the words of a statute and it's almost a little bit legislative where you're deciding what the law means. Here it's just simply making appropriations decisions removed from everything else that it's doing. So I think the initial non-delegation challenge to the CFPB might be more along the lines of Scalia's dissent in Mistretta.
Do we have a question online?
We do. Nathaniel Lawson thinks that the real problem here was that you didn't go after the Federal Reserve. And so what he asks is...
he's in the Go Big or Go Home camp.
Yeah. He is. He is in the Go Big or Go Home camp. Yeah. And notwithstanding the sort of Fed canon, is there an opportunity or is really the only thing left to go after the fact that that the Fed basically gets its own money and there's no appropriation, it's not appropriated. He asks, would you actually have, notwithstanding the Fed canon, more luck going after the Fed's funding mechanism as opposed to the CFPB?
I think, based on what I said before, that you're another step removed with the CFPB, that it was easier to attack the CFPB than it is to attack the Fed's funding. I think everything they said in this opinion about customs and so forth is all things that you could say that they're a closer analogy for how the Fed is funded than they are to how the CFPB is funded. So
yeah, totally agree.
I think Nathaniel's probably barking up the wrong.
And also, Justice Alito was freely admitting in his dissent that he thought the Fed was just fine. He thought that there was a long history of the First National Bank, the Second National Bank, that this had been going on so long that it was pretty clear that something along the lines of the Fed is constitutionally contemplated.
We're going to wind up here, so Lou, final thoughts from you?
Yeah, I'll offer a few. And thinking about how to restore checks and balances to the administrative state, I think we have to draw some somber strategic lessons from this case and to think, what is the art of the possible? What can the Supreme Court actually do? I think the answer is something, but not everything. And so we just have to have realistic expectations. Second thing, I think we need some more rigorous originalist thinking about what is legitimate originalist doctrine in constitutional law. This is a court that is thinking, I think, very seriously about what should the test be for these cases, whether it be in Bruin, whether it be the questions, from multiple justices in this case. What's the doctrine going to look like? How are future cases going to be decided? So I think we have to do some more thinking about what should doctrines look like going forward. And finally, a research agenda. Really, we need more people writing academic articles, more people analyzing the history. The current administrative law field is frankly just not getting it done a lot of the time. And that's a whole separate conversation as to why. But if this status quo continues, it will be enough to defeat these sort of structural constitutional claims merely to kick up some dust. And that's going to be easy to do because history is almost always complicated enough to do that.
If only there were a legal historian capable of writing magisterial works about administrative law, we might have a chance to get on top of this.
Yeah, well, and Lou's points were all well put, and I agree. And like I said earlier, I think that a real challenge now for administrative law scholars is to think more seriously about how the power of the purse fits into ordinary administrative law, not just in the all or nothing questions about who's going to have the money and how much, but what Congress's actions in passing appropriations laws means for the rest of the body of administrative laws, what that means in how we interpret the laws and how we how the courts carry out things like hard look review under the arbitrary and capricious standard of the APA.
Rich?
I am certainly not part of the go big or go home camp. I think that it is wise for those of us who see problems with administrative state to be looking at minor things to take on and not encouraging the court to make very broad rules. I think that Justice Thomas's decision here perhaps suffered from the same sorts of problems of his decision in the Bruin case, that he saw the need to come up with a rule that would apply to all future cases. And I think that the court now is beginning to realize that maybe the Bruin rule doesn't effectively deal with all the possible gun issues that could come up. I think the same problem here, that by coming up with a simplistic definition of what is an appropriation, it does provide a clean rule, but it really kind of cuts off any further efforts to try to control future Congresses. And I think it's an open invitation to future Congresses to go even further than the CFPB and what they do to entrench administrative agencies. And I'm hoping that at some point in the future, people will realize that and say maybe the clean rule that Justice Thomas came up with is not such a good idea, and there have to be some kind of limitations.
Well, we'll let that be the last word on this subject. I hope you'll join us for more Lunch and Law episodes in the next month or two. We have 3 cases pending at the U.S. Supreme Court here at NCLA. The Garland v. Cargill case, the Murphy v. Missouri case, and the Relentless v. Department of Commerce case. We're, I think, cautiously apprehensive was what one of my colleagues said about the results of these cases. Maybe more apprehensive after the CFPB decision, maybe less apprehensive after the NRA v. Volo decision that we didn't talk about. But anticipate having Lunch and Law episodes on each of those cases as they come out. Would all of you please join me in thanking our esteemed panel for how could SCOTUS get the CFPB